If I could have voted this year in America's presidential election, then I would have voted for Donald Trump. I am under the impression that, as a Norwegian, this puts me in a seemingly rather small minority within the context of where I live and relative to my extended circle of friends. I would be surprised if 25% of the people I know in Norway would have voted the same way as me. The interesting part, however, is not merely that I am in the minority. The really interesting part, the kicker, is that my views on this topic diverge so hard from the ones presented by Norwegian legacy media that I believe many people I know would write me off as a deranged, conspiracy, MAGA cult member, crazy person if they knew what I believed about the ongoing presidential election. In order to understand why I believe this to be the case, allow me to draw your attention to the following article. This article was published by Dagbladet, which I believe is Norway's third or so largest newspaper. The article is about a ruling made on December 9th by the Supreme Court of the United States, pertaining to a lawsuit filed in Pennsylvania. Before I can elaborate on how absurd I find this article, I need to provide some context by explaining what the lawsuit being ruled on is all about. On October 31st, 2019, Pennsylvanian Governor Tom Wolf implemented a law called Act 77. Act 77 expanded the opportunity for Pennsylvanian voters to vote by mail. The law defines a qualified mail-in elector as, quote, a qualified elector who is not a qualified absentee elector, and, as I understand it, allowed no excuse mail-in voting. This means that if you were a Pennsylvanian who wished to vote in any primary, general, or special elections, then you could do so by submitting your ballot through the mail without needing to provide any reason for why you wish to do so. This is the system that was in place during the 2020 presidential election. More than 2 million Pennsylvanians voted in that election by submitting mail in ballots. On November 21st, 2020, a lawsuit was filed in Pennsylvania by 8 plaintiffs. The lawsuit's introduction reads as follows, quote, this is an action seeking a declaration that the universal mail-in ballot provisions of a law called Act 77 are unconstitutional, and an injunction prohibiting certification of the results of the November 3rd, 2020 election in Pennsylvania, and/or requiring any such certification to be rescinded, and for other appropriate relief. Act 77 is the most expansive and fundamental change to the Pennsylvanian voting code, implemented illegally, to date. Under the Act and the mail-in ballot scheme it implements, any and all qualified electors are eligible to vote by mail, and no justification needs to be provided. As with prior historical attempts to illegally expand mail-in voting by statute, Act 77 is another illegal attempt to override the limitations on absentee voting prescribed in the Pennsylvanian Constitution without first following the necessary procedure to amend the Constitution to allow for the expansion. Put simply, this lawsuit is asking the courts for two things. The first is a declaration that Act 77 is unconstitutional, which I believe would result in the law being removed. The second is an injunction, which is a court order requiring a party to do or to refrain from doing something specific. In this case, the lawsuit is asking the court to retract certification for the November 3rd elections on the grounds that the Pennsylvanian elections were held in an unconstitutional manner. An important detail to note at this point is that rescinding verification for the November 3rd election would not only have an impact on the presidential race, it would potentially also impact every other down ballot race in Pennsylvania, which includes the ones for Congress, as well as other local elections. This detail is important because two of the plaintiffs, Mike Kelly and Sean Parnell, both ran for Congress in Pennsylvania. While Sean Parnell narrowly lost to an incumbent, Mike Kelly was re-elected to the House of Representatives. Note, Mike Kelly won re-election, but still filed a lawsuit seeking to rescind the election's certification. If the courts were to go through with this, then it could result in Kelly ultimately losing his seat. I believe this demonstrates a genuine concern over election integrity. You are, of course, free to draw your own conclusions. To reiterate, the lawsuit claims that the changes implemented by Act 77 were unconstitutional. On what grounds are they basing this claim? The section of Pennsylvania's Constitution that deals with absentee voting is paragraph 14. It clearly specifies the conditions under which an individual may submit an absentee vote. The conditions are as follows. Quote, because their duties, occupation, or business require them to be elsewhere, or who, on the occurrence of any election, are unable to attend at their proper polling places because of illness or physical disability, or who will not attend a polling place because of the observance of a religious holiday, or who cannot vote because of election day duties. According to Pennsylvania's constitution, these are the only conditions under which an individual may cast an absentee vote. In every other circumstance, individuals in Pennsylvania must vote in person. In order to change these conditions, in order to implement universal no-excuse mail-in voting, for instance, one would have to pass a constitutional amendment. The process through which this is done is as follows. A proposed constitutional amendment must be approved by a majority vote of the members of both the Pennsylvanian House of Representatives and Senate in 2 consecutive legislative sessions. The proposed amendment must then be published for 3 months ahead of the next general election in 2 newspapers in each county. Finally, it must be submitted to the qualified electors as a ballot question in the next general election and be approved by a majority of those voting on the amendment. At this point, if the proposal receives a majority vote by the Pennsylvanian electorate, then the amendment becomes part of the state constitution. According to the lawsuit, Act 77 made changes to a constitutional provision without going through the required legally mandated process. Furthermore, the lawsuit alleges the following. Quote, the legislature first recognized their constitutional constraints and the need to amend the Constitution in order to enact mail-in voting, sought to amend the Constitution to lawfully allow for the legislation they intended to pass, and subsequently abandoned their efforts to comply with the Constitution, and instead enacted Act 77, irrespective of their actual knowledge that they lacked the legal authority to do so, unless and until the proposed constitutional amendment was ratified by approval of a majority of the electors voting on the proposed amendment. In other words, the lawsuit alleges that the individuals who passed Act 77 did so despite knowing that they did not have the legal authority to do so. Why would they allege something like this? On January 29, 2019, the Pennsylvanian General Assembly began the process for amending the Pennsylvanian Constitution. The suggested constitutional amendment read, quote, Pennsylvania's current constitution restricts voters wanting to vote by absentee ballot. These restrictions are the ones detailed in the Constitution that we read through earlier. Moving on. Quote, we propose to amend the Constitution to eliminate these limitations, empowering voters to request and submit absentee ballots for any reason, allowing them to vote early and by mail. On March 19, 2019, the proposal was filed as SB, meaning Senate Bill, 413. After receiving some amendments, SB 413 was passed by a majority of both houses and was filed with the Office of the Secretary of the Commonwealth on April 29, 2020. In its current form, the bill seeks to amend the state constitution in the following manner. Quote, Section 14 of Article 7 will be amended to read, Paragraph 14, absentee voting. The legislature shall, by general law, provide a manner in which qualified electors may vote. A law under this subsection may not require a qualified elector to physically appear at a designated polling place on the day of the election. The General Assembly went on to establish a select committee on election integrity to, quote, investigate, review, and make recommendations concerning the regulation and conduct of the 2020 general election. The resolution establishing the committee noted the following, quote, this Commonwealth has traditionally only allowed absentee voting by individuals with a statutorily defined excuse to do so, such as a physical disability or absence from their municipality on election day. Before the enactment of Act 77 of 2019, for an individual to vote absentee in this Commonwealth, the individual must have provided a permissible reason to do so. Act 77 of 2019 created a new category of mail-in voting, whereby mail-in voters do not have to provide a customary reason to vote by mail and are able to return their ballots several days later than had traditionally been allowed. The lawsuit points out that for SB 413 to become law, It must again receive a majority vote in both the Pennsylvanian Senate and House of Representatives in the upcoming 2020 to 2021 session. If the General Assembly again passes the proposed amendment in that session, it will then need to be published publicly in 2 newspapers in each county for 3 months prior to the 2021 general election, and then be presented to the voters as a ballot question. Only if a majority of the voters who vote on the ballot question vote in favor will the amendment become law. Given these facts, why did universal mail-in voting become a feature in this year's election? The answer to that question is Act 77. As previously mentioned, Act 77 was signed into law by Pennsylvania's governor, Tom Wolf. The act changed the way in which voting was done by creating a new category of mail-in voters, which allowed them to vote in a manner which is not permitted by the state's constitution. This is precisely what the ongoing lawsuit is seeking to remedy. Now that you are familiar with what the lawsuit is all about, I am going to provide a brief overview of the events that caused it to end up in front of SCOTUS. The lawsuit was initially presided over by Pennsylvanian Judge Patricia A. McClellow. On November 25th, she granted the lawsuit's injunction to halt certification of the Pennsylvanian elections, pending an evidentiary hearing that was scheduled for November 27th. Immediately after the judge's order was entered, the Pennsylvanian General Attorney tweeted that his office would be appealing the court's order. A notice of appeal seeking to have the Pennsylvanian Supreme Court review and overturn the Commonwealth's court's injunction was filed. The Supreme Court of Pennsylvania decided to accept the appeal. Pending the lawsuit's appearance in the state Supreme Court, Judge Patricia filed a memorandum opinion defending her decision to grant injunction. I am going to read one part of her opinion, because I find it particularly interesting. Quote, "Petitioners appear to have established a likelihood to succeed on the merits, because petitioners have asserted the Constitution does not provide a mechanism for the legislature to allow for expansion of absentee voting without a constitutional amendment. Petitioners appear to have a viable claim that the mail-in ballot procedures set forth in Act 77 contravene PA's Constitution, Article 7, Section 14, as the plain language of that constitutional provision is at odds with the mail-in provisions of Act 77. Since this presents an issue of law which has already been thoroughly briefed by the parties, this court can state that petitioners have a likelihood of success on the merits of its Pennsylvania constitutional claim. It seems to me that this judge does not view this case as a frivolous lawsuit. It appears, in fact, to be quite the opposite. This judge seems to agree that Act 77 was, in fact, unconstitutional. I'll get back to why I'm stressing this point once I get to the Norwegian article. First, we still need to get this case to SCOTUS. The appeal of Judge Patricia's injunction was taken up by the Pennsylvanian Supreme Court. On November 28th, they declared the following, quote, "And now, this 28th day of November, 2020, we grant the application for extraordinary jurisdiction filed by the Commonwealth of Pennsylvania, Governor Thomas W. Wolf, and Secretary of the Commonwealth Kathy Bookvar. Vacate the Commonwealth Court's order preliminarily enjoining the Commonwealth from taking any further action regarding the certification of the results of the 2020 general election, and dismiss with prejudice the petition for review filed by the Honorable Mike Kelly. All other outstanding motions are dismissed as moot. Upon consideration of the parties' filings in Commonwealth Court, we hereby dismiss the petition for review with prejudice barred upon petitioners' failure to file their facial constitutional challenge in a timely manner. Petitioners' challenge violates the doctrine of laches, given their complete failure to act with due diligence in commencing their facial constitutional challenge, which was ascertainable upon Act 77's enactment." I'm not a lawyer, and so I found someone who is a lawyer to explain this ruling.
The lawsuit was dismissed on the grounds that the vote has already occurred. People voted on the basis of the constitutionality of that lawsuit. And so, too late, theory of the latches, you can't sue now and we can't grant you the relief because they've already voted. If you wanted to challenge the constitutionality, you should have done it before. The flip side to that, not to create a straw man argument because this is not the argument that's been used, but in other cases, they've said you have not yet suffered an injury. In fact, it's the reason why the federal suit was dismissed. And so you can't sue because you haven't suffered an injury yet. And typically in constitutional law, you don't just go around challenging laws because you want to, you have to have an interest in doing so. So this is the catch-22 where some are going to say, even if they had filed it beforehand, it would have been dismissed because there was no injury in fact. Now it's being dismissed because the injury is done fait accompli. So it's sort of this judicial catch-22. First of all, what's your take on it? And is it the same thing in the States? Like you have to wait for there to be an actual issue to challenge the constitutionality of a law?
The Pennsylvania Supreme Court that has made many, many strange rulings in this throughout this entire election period didn't even wait for 24 hours to rush in and shut it down. And the Democrats were very aggressive, and they were the ones who came up with this latches theory, which I've dealt with in the election law context. And the Republican judges dissented on the latches issue, but said they didn't really want to get involved in setting aside the election, but did think there was a serious constitutional question that needed to be addressed.
What I take away from this is that the original lawsuit was not dismissed based on the merits. The Pennsylvanian Supreme Court did not dismiss the lawsuit because their legal arguments were invalid. Instead, the lawsuit was dismissed on procedural grounds. The lawsuit was apparently not filed in time, and therefore the state Supreme Court decided to throw it out. At this point, it seems to me to be the case that the way in which Pennsylvania conducted its election was indeed unconstitutional. The plaintiffs, of course, decided to appeal the new verdict. This appeal brings the case into the jurisdiction of SCOTUS. You will recall that the lawsuit consists of two parts: asking for Act 77 to be declared unconstitutional, and an injunction for the court hearing the case to halt election certification. On December 8, 2020, SCOTUS declared the following, quote, "The application for injunctive relief presented to Justice Alito and by him referred to the court is denied." SCOTUS has thus decided against allowing one part of the lawsuit. However, this does not mean that the Supreme Court has thrown out the case entirely. A decision has not yet been made as to whether the Supreme Court is going to hear the case regarding Act 77 or not. At the time of writing, this is the current status of the lawsuit. Okay, now that you have been brought up to speed, now that you know the context surrounding this specific SCOTUS ruling, I can finally start ranting about just how much this article annoys me. Starting with the title and opening sentence. Quote, "Rejected with one sentence. The Supreme Court of the United States made it perfectly clear that they would not rule in favor of Trump winning the Pennsylvanian election." I mean, what the fuck is this? This lawsuit has nothing to do with Donald Trump. Sure, the results of the lawsuit may have an impact on the presidential election, but that is not guaranteed. Even if SCOTUS decided to hear the case and judges Act 77 to be unconstitutional, this would not automatically result in Trump being declared the winner of Pennsylvania. I am under the impression that SCOTUS would be who decides what constitutes the, quote, appropriate relief being asked for. But okay, to be fair, maybe including Trump in the introduction is just clickbait to get people to read the article. I can't exactly blame them for that, given that I do the same thing to get people to watch my videos. Let's read on to find out. The first few paragraphs provide a relatively succinct summary of the lawsuit. I don't have any major problems with what they've written here. It's more or less a TLDR version of the context I provided, written in as few words and with as few details as possible. A few paragraphs further down, however, Dogbrother writes the following regarding the unanimous SCOTUS ruling. Quote, "Thus, not even the judges appointed by Trump himself apparently agree that he won the election." At this point, I'm scratching my head. The lawsuit is not about whether Trump won the election. It's about whether a state election was held in a legal manner or not. What's more, the lawsuit itself has not been dismissed in its entirety, so we still don't ultimately know what will come of it. SCOTUS can still rule on the constitutional questions raised in the lawsuit. So why does Dogbrother keep spinning this to be all about Trump? Let me draw your attention to the caption under the video displayed at the top of this article. It reads, quote, "America's outgoing president, Donald Trump, was at an election rally in Georgia on Saturday night. There, he repeated a number of undocumented allegations and lies about voter fraud." Further on in the article, we are given a so-called expert opinion from a person who is supposedly an expert on American politics. Regarding the SCOTUS ruling, we are told, quote, "This was as expected. The Trump team has neither had facts nor the law on their side in all of these frivolous lawsuits. That has been the red thread throughout the entire process." Remember earlier when I was stressing the point that Judge Patricia believed the lawsuit would succeed on its merits? Remember when I pointed out that the PA Supreme Court dismissed the lawsuit based on procedural grounds, not factual ones? Now you know why. The so-called expert quoted by Dagbladet is either uninformed or he's a liar. I believe one of two things to be true regarding this article. Either the people who wrote it don't actually know anything about the topic that they are writing about, or they are being deliberately misleading. The article begins by implying that the SCOTUS ruling demonstrates that they are opposed to Trump, when the case they ruled on had nothing to do with Trump personally. The article then claims that Trump was at a rally spewing undocumented allegations and outright lies regarding voter fraud, a claim which is also totally unrelated to the lawsuit in question. Finally, the article dismisses this and every other ongoing lawsuit as frivolous by claiming that none of them have any factual or legal basis, insinuating that this whole case is based on lies. To any Norwegians that happen to be watching this video, if articles like this form the basis of what you think you know about the US elections, then I believe that you are uninformed. If Dagbladet is willing to do work as sloppy as this about one lawsuit, then what makes you think that the standards will be any different in whatever else they happen to be reporting on? Allow me to speculate for a moment. I do not know how the US election is being reported on elsewhere in Europe, but supposing that it's similar to what we have seen here in Norway, what will happen if SCOTUS actually rules in a manner that results in Trump being re-elected as president? Personally, at this point, I don't believe that it's likely to happen. However, I don't believe that it's impossible either. Based on what I have just presented from the Pennsylvanian lawsuit, I believe that the Pennsylvanian election was indeed held in an unconstitutional manner. Suppose for a moment that SCOTUS agrees with me, and that their ruling on this and several other lawsuits does result in Trump being re-elected. What then? What happens in that case when most European citizens have been led to believe that every action taken that might potentially win Trump the presidency was illegitimate? While your guess is as good as mine, I'm going to conclude this segment with a clip from the podcast of the Lotus Eaters. I'm of the opinion that this clip represents a pretty good guess.
I mean, what do you think will happen? I mean, if let's say Trump refuses to give a concession speech, then what?
Well, the Democrats and the media have been priming everyone for the last 4 years to believe that Trump is a dictator and that he's not going to relinquish power and that he is going to do something illegitimate in order to maintain his grip over the United States. And not that he is much of a dictator by any measure, but it doesn't matter, you know. This is the narrative. And so there are definitely going to be millions of people who buy into the democratic narrative who will believe that Donald Trump has committed some kind of Caesarean coup in the United States. It seems to me, as an outsider who has no legal expertise in this regard whatsoever, but just as a layman reading the documents, reading the allegations, looking at the evidence independently, I just don't see how an independent observer could know what has happened and come to the conclusion the Democrats have done nothing wrong here. But like I said, the followers of the Democrats are going to think that Trump is an unjust tyrannical dictator, even though he's done nothing unconstitutional. All of this is completely within the realms of the Constitution, all of it. And, you know, I mean, I listen to lots of other Republican podcasters. I listen to lots of left-wing podcasters, and the left-wing podcasters are never really addressing the meat of what the Republicans are claiming, like the actual allegations.
Like, they can't address any of the things, because to address them would to mean that it's not a big conspiracy theory, as they say.
Exactly.